So we have two outstanding speakers for this session. We have Jack Coop and we have Dr. Elaine McDonald, who are going to be giving us a few different perspectives, one the legal perspective and the other the scientific perspective. So we'll begin with Mr. Coop.
Thank you very much, Heather. We've got a lot to cover and not a lot of time to cover it in, so I'll very briefly tell you about myself. I started out as a summer student at CELA when I was a law student, and then I was in private practice as a civil litigator, and then in 1988 I joined the Ministry of Environment, and I did hearings and prosecutions there for 10 years. And then I went to the Ministry of the Attorney General. I went back to doing civil litigation and judicial review, mainly in relation to environmental cases, but not exclusively. And then in 2008, I was fortunate enough to get brought over to Osler, where I've been in private practice, back in private practice since then. So I think it's fair to say I've seen all sides of the case. I certainly understand the Crown side of the case. What I'm hoping we can do today is look at a fairly high level at some of the critical law that relates to the collection of evidence and the use of evidence during an investigation and prosecution. And these are really, someone asked me, oh, you must have so much to say. Not really. I managed to squeeze just about everything I know into 20 pages, and it's in your materials. And I'm not going to be reading that, so we should be able to move along pretty quickly. So let's just see. That is not mine. This is Jennifer's, I bet. Okay, so could we load up my, my presentation? It's the one that begins, collecting essential evidence for environmental investigations and prosecutions.
Record under your name.
That's interesting, but that's not my paper. So why don't I give you my paper? It's possible that I emailed the wrong thing to you, so if I did that, I apologize.
Any jokes while we're reading?
Yeah, jokes. Hear about the one about the lawyer who came with the wrong presentation. That's it. Yay. Beautiful. Fantastic. Okay, so we're off and flying. So this is evidence nuts to bolts for investigations and prosecutions. There's a huge number of things that I cover in the paper, and I'm going to deal with it all at a very high level. So the ladder of enforcement, you heard about the triangle of enforcement from a number of guests. That's all the ladder is. So we know that the preference of government, because of resource limitations, is to do most of it as voluntary abatement, then approvals, admin orders, environmental penalties, and finally, for the really badass cases, quasi-criminal investigations and prosecutions. So the reason that's important, we're dealing with this. We're dealing with number 5 now. The reason it's important is that by the time you get to number 5, you got a problem. The relationship between your client and the regulator has deteriorated. The regulator has already concluded that your client is not responsive to voluntary compliance, to its approval obligations, to admin orders that have been issued, and that the only way that it's going to be able to force your client to comply is by prosecuting, or that your client has done such an egregious thing that they need to be punished or deterred in the future, and a message sent to the public in the way of general deterrence. So it's a bad situation to be in, but the evidentiary implications for us is that we're talking about public welfare offenses. The key to that is that, as you all know, there's a defense of due diligence. for a public welfare offense, including environmental prosecutions. And I've got the quote from Sault Ste. Marie on page 5 of my paper. The defense will be available if the accused reasonably believed in a mistaken set of facts which, if true, would render the act or omission innocent, or if he took all reasonable steps to avoid the particular event. So that sounds like a simple test, but it's a high hurdle to meet. And we're going to talk a lot about evidence that relates to that defense of due diligence in this presentation. So going into an offense, what it really means is if your client has committed the actus reus of the offense, has done the deed, public welfare legislation assumes, and the Crown assumes to some extent, that your client was negligent, right? Because if you read Wholesale Travel, the Supreme Court has told us that this is what it's all about. You enter into the scheme, and it's okay to have a reverse onus because, you know, you're agreeing to operate your business in a non-negligent manner. So the assumption here, we're not dealing with mens rea offenses. We're dealing with offenses where the Crown only has to prove the actus reus, your client has a due diligence defense. The assumption is that you were negligent. So the accused, another implication is the accused, and you as the accused lawyer have to assess if there's compelling evidence that the client was not negligent. And finally, and a really important point I'm going to emphasize over and over, is that the accused has to put systems in place to assure that there's due diligence in the future. And we'll talk about why that's important momentarily. So the first heading here is legal strategy for stopping a prosecution before it starts, because in my view, you're really not fulfilling your role as a proper environmental practitioner unless you're helping your client to avoid offenses. It's not simply a matter of responding to the investigation after the fact. The most important step for avoiding this type of prosecution is to achieve due diligence. So what is that? Well, what I typically will do is I'll provide my client with the factors from the Commander business case. And you'll see those factors set out on pages 5 to 6 of my paper. But, you know, it includes nature and gravity of the adverse effect, foreseeability of the effect, alternative solutions available, legislative and regulatory compliance, industry standards, character of the neighborhood, what efforts have been made to address the problem, over what period of time, promptness of response, was the matter beyond the control of the accused, etc., etc., etc. Preventive systems in place, complexities involved, a lot of different factors. Okay, why do I do that? I'll come back to this again later, but the client has to know what due diligence is, because otherwise they can't implement it. So you have to teach them. That's number one. It's also critical for defending an environmental prosecution that the client knows, so the client can get you their evidence of due diligence, if there is any. So the second way of avoiding a prosecution before it stops is to get your client to implement an environmental management system. They have to have one, they have to vigorously implement it, and they have to document their implementation. What's a proper system? This is set out in a number of cases. I'm citing the Bata, the Courtaulds, Fibers decision, and the Syncrude decision. And you'll see this on pages 6 and 7 of my paper. But just to give you an example, Bata, you have to have a reasonable and realistic corporate policy, adequate commitment of resources, no omission identifying environmental impacts within the organization's control, and up-to-date legal requirements. Syncrude. The judge stated, to meet the onus, Syncrude is not required to show that it took all possible or imaginable steps to avoid liability. It was not required to achieve a standard of perfection or show superhuman efforts. It is the existence of a, quote, proper system, unquote, and, quote, reasonable steps to ensure the effective operation of the system, unquote, that must be proved. So there's an emphasis in many of the cases that due diligence necessitates a proper system. All right. And there's a much longer discussion of this in the paper. The issue also comes up of how you ensure that directors and officers can be duly diligent, because as you know, under most environmental legislation in Canada, there's a lot of provisions for individual liability for directors and officers. And I was chatting with Katya earlier in the day, and we were talking about how directors and officers really care about those provisions because they don't want to go to jail and they don't want to pay these fines. So again, we get some guidance from BATA. You'll see this on page 8 of the decision of my paper about what directors and officers have to do to be duly diligent. Did they establish a pollution prevention system? Did they ensure it had proper supervision, inspection, improvement in business methods, compliance with industry standards, compliance with environmental laws? Did the directors exhort those under their influence to implement the system, to report back? Were the officers instructed to report any substantial noncompliance? Did the directors review the environmental compliance reports received through the system? You know, it doesn't make any sense to have a system in place if no one's reviewing it and implementing it at the level of the board of directors. Were environmental problems promptly addressed? Were they aware of industry standards? Did they immediately and personally react to resolve the problem? So that's how you avoid a prosecution. But then you will have situations where the client comes to you and they're being investigated. So what is an investigation? I don't have to deal with this because it's been covered already. Fred talked about the predominant purpose test. So did Jamie. In terms of the evidence that's sought, I think this was also touched upon. The investigators are looking for everything: documents, samples, statements, computer hard drives. But they need a warrant to get this, right? If you're in an investigation mode, they can't just walk in and rely on their statutory powers. They have to have a warrant. So that takes us to that question that I think Fred dealt with quite completely. How do you tell an investigation from an inspection? Pretty easy in Ontario because of the 2 branches, but dealing with the federal government, it's not so easy. In my paper, I talk about what the investigator can do and not do. Cannot compel disclosure with statutory powers. And then I talk about all the different inspection powers that they don't have. They can seize documents in plain view, although there's some case law now that suggests that maybe an investigator can't. They can obtain a preservation order under many statutes, occupational health and safety, to basically close the site and preserve the evidence. So what kind of questions should you have for the investigator when they come to tell if they are doing an investigation or an inspection? Well, you can ask them, do you have reasonable and probable grounds that an offense has been committed? You can ask them, are you doing an inspection or an investigation? And, what's your predominant purpose? And also you can ask them, is my compliance with your investigation statutorily compelled, or is it voluntary? If it's voluntary, you're in an investigation. All right. I also talk about obstruction. And for a definition, turn to page 11 of the paper. I don't know how many people will actually have the materials, but obstruction means hindering or obstructing the investigator's performance of their duties. It can also include submitting false or misleading information, and it can be refusing to furnish information that's required. In terms of inspection versus investigation, obviously there's a lot more room for obstruction in an inspection than an investigation because the inspector has all those statutory powers. So if the inspector has the power to ask you for information and you don't give it, well, you've been obstructing the inspector. Whereas in an investigation, if the investigator asks you for a voluntary statement and you say no, it's not obstruction. You have a right to a lawyer during an interview. That's usually protected by statute, but also under the Charter. And you have a right to respond in a limited manner. So what do I mean by that? Is that where an inspector or investigator asks for information, even if it's compelled, short of being misleading, you don't want to be misleading, you only have to provide the documents requested and only answer the questions asked. You don't have to volunteer more. In terms of voluntary compliance with an investigator, again, you can control the amount of information that's provided. And generally, investigators will know what they want, and you can often ask them to give you a list of what sort of documents do they want. And then you can decide, are you going to provide those, or are you going to compel the investigator to get a search warrant? How to handle confidential information? Well, first of all, what is confidential? It's anything marked, privileged, and confidential. That should be a starting point. Certainly any communications with you as the client's lawyer. And finally, consultants' reports that have been commissioned by you or by a lawyer on behalf of your client in confidence. So most statutes provide for this, but essentially the method is to, when the investigator wants to seal those documents and you're objecting that they're privileged and confidential, you can't stop the investigator, but you get it put in a sealed envelope or box, and then it goes before the court, and you can bring a motion to have a judge or a JP determine judicially whether in fact they're confidential. How do you handle a search warrant or an inspection order? Well, you have to look at whether it was properly obtained and executed. So, for example, in Ontario, under the Provincial Offences Act, you can only use a search warrant at the location expressly authorized. It expires within 15 days of issue, and it has to be executed between 6 a.m. and 9 p.m. And then, of course, what I just adverted to is you may not want to force the investigator to exercise a search warrant because it can be extremely disrupting to a business. And you can avoid disruption by complying voluntarily. So if you have the option and the investigator says, look, I don't want to execute a search warrant, but I need these documents, you have a decision point, and you can decide to provide them. And the values of doing that are that, one, you can limit the documentary disclosure. So the investigator's not collecting all your files. She's only getting a selection of them. You can attempt to avoid disclosure of self-incriminating documents, such as internal audits and investigations, if they're not directly relevant to the investigator's request. And the investigator may be investigating offense A, and your client knows about offenses B to G, but the investigator doesn't know, you're not obliged to disclose that, and avoids business disruption. Also, it's very important to have an investigation protocol and checklist in place. So what is this? It's a document that's basically a guidance document to the client on how to respond when the investigator comes knocking. So it includes things like, what is the role of the receptionist? Who's going to be the point person to actually take the investigator through the facility? Make sure the investigator's safety is safeguarded. Make sure the investigator isn't wandering into areas collecting evidence of other offenses when they're there to deal with one particular issue. Who is going to answer the investigator's questions, if anyone? Who's going to contact the lawyer? When should they contact the lawyer? What do you do about a closing audit or closing interview? Should the lawyer be there? What about employee interviews? All these things can be covered in an investigation protocol and checklist so that everyone knows at the client what their roles are and how to minimize exposure to liability. I've got a note to myself to read you something on employee interviews. No, I don't think that's critical. But down here, under the subject employee interviews, that's a really interesting subject. So, enabling your employees, your client's employees, to give interviews to the investigator creates a serious risk of liability for corporate clients. And there's also a huge risk of finger pointing because, of course, the employees are scared and they don't want to take the blame. They don't want to lose their jobs, but they want to appear cooperative and not get charged. Employees need to know that they have a right to refuse interview if it's a voluntary interview, right? But who's going to give them that advice? It should not be the company lawyer. Because if, as the company lawyer, you're giving the employee advice, then you're the employee's lawyer. What happens if the employee testifies against your client in court? You can't cross-examine them. You can't cross-examine your own client. So there are many advantages, and I often recommend to my corporate clients to assist the employee in obtaining independent legal advice. And quite often you can have one lawyer at another firm representing a whole slew of employees on a joint retainer basis, provided there's disclosure and consent within the rules of the Law Society. And it's a very good system because it allows the independent lawyer to communicate with corporate counsel, so I'm certainly free to share my theory of the case with him or her and tell them why I don't think the employee has to give an interview. It also postpones the interview to some extent so the employee can get some legal advice and some preparation before they're interviewed if they choose to be interviewed. And then it also allows the employee to get some advice and confidence without the company lawyer present so that they can feel confident that they're being assisted. All right. So then we're in a prosecution. How do you handle that? The charges have been laid. How am I doing time-wise? Almost up. You want to try and control the number of witnesses. You want to prepare those witnesses. The company lawyer, if you're going to be the trial lawyer, you should not be attending the interview of the employees or the witnesses, even the management witnesses. Why? Because you'll become a witness at trial. There's a voir dire on the voluntariness of the statement, you may be called, and then you can't act for the client. So you would send an associate to do the job. You don't offer up your employees. We already talked about that. And you don't arrange employee interviews either. And you further clarify to the investigator in the Crown that the employee does not speak for the company. A good example of this not happening was the Syncrude Oiley-Ducks prosecution. And the company lawyer facilitated the employee interviews. All those interviews went in as admissions against interest against the company without the employees even testifying at trial. So the objective with employees is to circle the wagons with them, interview them with ILA present, and keep them on side. Then we move to the subject of Crown disclosure. You must always demand Crown disclosure, because if you don't, you may not get it. And you have to ask for full disclosure. And most important, make your request specific to your case. If you know there are particular issues which may be the Achilles heel of the prosecution and maybe the saving grace of your client's due diligence defense, and you don't see that in the Crown's documentation or you have reason to believe it might not be there, you ask for it. Force the Crown to confront bad evidence for the Crown's case, good evidence for your case. So limitation periods is another issue. It's an evidentiary issue. All these issues, these are tactical legal issues in a prosecution, but they're all evidentiary issues as well. So in Ontario, under provincial prosecutions, under the EPA and OWRA, there's a 2-year limitation period. I think federally it's different. I'm not sure is it 6 months for summary conviction offenses? What's the limitation period? Yeah. 6 months. And I think for indictable offenses, there's no limitation period. So that that wouldn't apply, although there might be under some of the federal statutes. I'd have to check that. If you think there might be a limitations issue, that is, the Crown's case is run and charges were laid too late, you have to ask for evidence relevant to the limitation period, right? Because the Crown may not have seen that before. The investigator may not have thought of it, or may have thought about it and sort of worried about it and didn't put it in, but there may be some emails back in the ministry, not in the investigator's file, maybe on the abatement side, in which abatement found out about the offense a year earlier. And this has been a continuing offense. Well, you want that evidence because you want the Crown to look at it and think, these charges might get struck out at trial. Client disclosure, you got to obtain it. Don't assume that all the documents are going to be in the Crown brief. They won't. The Crown will have a smattering of the evidence. You have to obtain the client's evidence. Why? Obviously, you can't assess whether the Crown's going to be able to prove actus reus, but more important, you can't assess your client's due diligence defense until you see what they did and why they did it. So that's absolutely critical. And that's to be contrasted with many criminal prosecutions where, if you talk to a criminal lawyer dealing with, B&E or something, and they're interviewing their client, they're going to say to the client, okay, I don't want you to tell me what you know, but can you tell me what is the Crown going to say you did, right? Because they don't want to hear the accused's admission of liability because then they can't represent the accused at trial. This is different. In most cases, in most environmental and regulatory cases, you do want to know. Why? It's not a mens rea offense. It's a due diligence, public welfare offense. You want to know, does your client have evidence of due diligence? I mean, dollars to donuts, the action occurred, or you wouldn't be facing charges. That's not the issue. The question is, why did it occur? Okay. Co-defendants. Missing client disclosure. So you get the documents from the client, and you go through it, and you think, wait a minute, where's their maintenance system? Where's their audit system? Where's the reporting system? There's stuff missing here. Well, you don't just let it lie. You go back to the client and you say, where's this, where's this, where's this? And the client may say, oh, forgot all about it. Here it is. Or the client may say, well, we don't have one. Then you go, oh, okay. We have some talking to do. But you have to ask, right? You never know. Circle the wagons with co-defendants. In most cases, co-defendants are on the same side of the case. And you can reach a lot of agreements with co-defendants. You can enter into a common interest privilege agreement to share. You can agree you're not going to give any interviews to the Crown. You're not going to point fingers at one another. You're going to agree on defects in the Crown's case. You might even agree on some kind of a strategy to respond to the prosecution. In many cases, you can do that, and it can be helpful. But in a very limited number of cases, quite rare in my experience, you might be able to enter into a Crown immunity agreement. And that's where you can't circle the wagons with co-defendants because they're to blame. And your client is actually an innocent victim of the co-defendant. So that can happen in cases, for example, where your client hired someone to do a job, and they were acting effectively as your client's agent, and they did a terrible job, and your client was pulling their hair out, screaming, you're breaching our contract, fix this, fix that, and they don't fix it. And pollution continues and continues. Well, in that case, you may want that co-accused to be prosecuted, and you may want to help the Crown to prosecute them, particularly if, as part of the agreement, you can get some kind of relief from liability. But that's a rare case, I admit that. And then analysis of the Crown's case, very important. What are you analyzing? The evidence. Does the Crown have evidence that your client committed the actus reus of the offense? Does the Crown have in the Crown brief evidence of due diligence? Is there evidence in the Crown brief that shows that the Crown has been misled by co-defendants? Is the Crown brief missing exculpating evidence? So, once you've done that analysis, you may conclude that you need new evidence. Are you still missing evidence? Why? The client didn't collect it. The client didn't speak to other witnesses. So you may task the client. You may say, you've got to analyze this issue. Retain a consultant or do this in-house. Or find these documents. Or do this research. Or you may go out yourself and interview new witnesses. And I can't tell you the number of times I've done that, and I'll find very helpful evidence that's exculpating to my client. Or you may recommend to the client that you retain an expert witness to respond to some of the expert evidence of the Crown. We talked about educating the client on due diligence and why that is critical. Due diligence after the fact, let's talk about that. So these are the steps taken since the offense occurred by your client to assure that the offense never occurs again. Right? So it's too late to constitute due diligence for this particular offense because it's after the offense. But it certainly shows goodwill, non-negligence, due diligence going forward. Why is it important? It's very important because in Ontario and Canada generally, the predominant purpose of sentencing is deterrence. And certainly a big part of that is individual deterrence of the accused. And if you can convince the Crown in settlement discussions that your client is reformed and they fix the problem and it's never going to happen again, the Crown's going to say, okay, maybe there's less reason to be harsh with this client. They've spent money on the problem, they've attempted to fix the problem, and the Crown might be willing to withdraw some charges, accept pleas on representative charges, or reduce the sentence requested if they have the flexibility to do so. So how do you do that? Well, you might commission a compliance audit through counsel. So, for example, the client has one charge. Am I running out? If the client has one charge, get an expert to come in and independently audit why that occurred and what needs to happen to fix it. If it evidences larger problems, you may need more than one audit, a bigger audit that's kept internal and confidential of the entire system. You have to assess reasonable prospect of conviction, and you have to advise the client if they're likely to be convicted. You have to be honest and unvarnished in your advice, and this will serve as a basis for settlement discussions. So very quickly, once the prosecution commences, you have to communicate with the Crown, keep the lines of communication open. That's critical. What do you discuss? Everything. Penalty. You provide evidence to the Crown with respect to penalty and plea, and then you consider whether to keep powder dry or to divulge evidence to the Crown. In most cases, you would give it to the Crown because this just ensures that you wind up with a trial. Settlement. There are many reasons why environmental prosecutions generally settle. There's the charge screening that Fred talked about. There's the cost of defending, which can be prohibitive and more expensive than the actual fine itself. There's the fact that the investigator often lays more than one count and gives the Crown some room to negotiate and drop pleas and take representative charges. So quite often they settle. When they do, make sure you document it. You can have minutes of settlement, you can have an exchange of letters, you can have joint briefs, an agreed statement of facts, agreed statements as to penalty, and so on. And then there's finally trial preparation. And I deal with this at some length in my paper. I won't now, but you got to prepare a trial brief, you got to prepare defense motions, prepare witnesses, prepare expert witnesses, and their reports. So at every single stage in the prosecutorial and investigative process, there's evidence, and there's a myriad of evidentiary issues that you have to respond to. And those responses include documenting the evidence, demanding the evidence from the Crown, disclosing and refusing to disclose, controlling the flow of evidence, protecting confidential evidence, finding missing evidence, generating new evidence, retaining, assessing, and acquiring a command of the evidence, and then finally presenting it at trial. So it's entirely an evidence-based process, and most cases will hinge not on the law but on their evidence. So we need to get a full grasp of that, and we need to engage in the nuts and bolts of evidence as defense counsel. Thank you.
That's great. Thank you. Thank you very much. Okay. So I have a couple of questions to start. The first is, how does an organization demonstrate due diligence in terms of corrective actions chosen without providing supporting information such as internal audits, which are possibly self-incriminating?
Well, sometimes the due diligence will be apparent on the face of the record in the Crown brief. Other times you may have to go out, as I indicated, and actually obtain evidence from new witnesses. You may have to obtain evidence from experts, and you may have to disclose internal audits or have an audit done relevant to the offense, and if the results do indicate that your client was duly diligent, you may wish to disclose it, but if they don't, you may not. Or you may wish to disclose it to show that the client, as I said just a minute ago, the client has taken steps to implement due diligence going forward. So that's how I would do it.
Great.
Yeah.
Is attorney-client privilege a separate category of non-discoverable, non-disclosable information from confidential business information or trade secret information?
Well, I think it probably is, and I'd have to go back and look at Section 160 of the Provincial Offences Act. I'm not sure that it's a broad protection against the disclosure of any kind of confidential information. I'm not sure that it would protect proprietary information from disclosure to the Crown. It may be limited to solicitor-client communications and documents prepared substantially for the purposes of litigation. So I would certainly treat them differently.
Any other questions from the floor?
No.
Yes.
You talked about encouraging employees not to provide information in witness interviews. What sort of factors in your mind would be the tipping point between that being an effective mitigation strategy going over to obstruction?
Well, I don't think I said that I would encourage employees not to give interviews, but what I would certainly do is I would try and make sure that they got independent legal advice, and I'd try to persuade their lawyer, if I thought that the interview was not mandatory but was voluntary and that it wasn't in the employee's interest to give the interview because they're a potential target of the prosecution, I would try and convince the independent legal counsel of that position. And then it would be entirely up to the independent legal counsel to advise the client. But I would never interfere, and I would never counsel my client to interfere to stop an employee from interviewing. But there are some things that I think the corporate client can do. They can say, look, you're free to give interviews if you choose to. We recommend you get legal advice. We're even prepared to pay for it or not. But we're not authorizing you to give those interviews on company time. So if you want to give the interview, by all means do so after work. But you're not doing it as an employee or on behalf of the company.
Thank you so much.
Welcome.
Okay, so we'll move on now to hear it from the scientific perspective. Thank you very much.
Oh, there we go. Thanks. Hi, I'm Elaine McDonald. My slide is a bit facetious because I'm actually not a scientist, I'm an engineer, so I thought I'd scratch that out and show it to you. I like to joke that when I was hired at EcoJustice, I was hired by Stuart Elgee, which I'm sure many of you know, that lawyers don't know the difference between scientists and engineers, so I was able to get away with being hired as a scientist even though I'm really an engineer. But anyways, my title does say scientist, so I've been living a lie, I guess, for many years. And moving on. So I felt a bit like Jamie when I was asked to do this talk because, of course, working at ENGO. Can you hear me okay? All right, good. It's in my face, was it? Had a big black thing in the middle of my face. Working at ENGO, it's not like I go and do inspections and investigations like a provincial officer or a federal officer would, but I do have some experience, and most of the experience that I can draw from came from this fellow, which some people may know who go back quite a ways. Doug Chapman. Oops, I have to advance both. There we go. Sorry. Doug Chapman. You know Doug Chapman. There we go. Doug Chapman basically taught me how to do investigations. I was hired at Ecojustice back in late '99. Doug was working there as a lawyer, and he was doing some private prosecution work. Of course, Doug's experience goes back far before that. He was a defense lawyer for many years, traveling the road doing criminal defense work. He then decided to become a sailor and sailed around the world, and after that he decided to take up fishing and became a fisherman out in BC. And after doing that, he decided he wanted to go back to the law, and that's when he joined the Ontario government as a prosecutor. After doing that for a while, I guess he had had enough, and that's when he came to Ecojustice. First, he went out to our Vancouver office. Does everybody know who Ecojustice is? Do I need to introduce Ecojustice? We're an environmental law, ENGO, do environmental law cases in Canada. And I'm not a lawyer, I'm a scientist there, obviously, but anyway, it's just that you have that basic understanding of who we are. We're a charity. Anyways, Doug went out and worked in BC, and he tried to do private prosecutions out in BC, but he just ran into them being stayed by the AG, so he didn't have any success. He tried to sue the city of Victoria for dumping raw sewage, which they're still doing to this day, way back. That was in the 90s, I do believe. And then he moved to Ontario and started working at the Toronto office. And there he did have some success with private prosecution because they weren't stayed. They were allowed to go ahead. There was the Fletcher and Kingston case. Then there was the Lukasik and Hamilton, which was a guilty plea at the time, the largest fine ever, $500,000 against the city of Hamilton for discharging. These were cases largely under the Fisheries Act for discharging dilatory substances into fish-bearing waters. That was Doug's favorite act. That's all he ever wanted to do was sue polluters under the Fisheries Act. And then Deloro, which was not successful. It was a due diligence. They got on a due diligence defense. But those were kind of the ones that I worked with Doug on, and that's where I kind of got my training, because when Doug joined MOE, we didn't have any investigators. He wanted somebody to help do the investigations, and that's where I came in. So that's my foray to Doug. Anyways, one of the things we'd have to do when we were go out to do investigations was do a lot of planning, because you just never know what you're going to need. You never know what you're going to come across. Transportation, site access issues were always a big deal. Like there could be trespass issues, like we might have to, how do you get to the site? Are you going to have to get through private land? You need to ask permission to get to the location. It wasn't unusual for us to use a boat if we needed to get to where we want to go. That picture up on the right-hand corner there is actually a site we were trying to sample where the pipe was discharging underwater. So we took a boat and we actually had a diver and we tried to get down and get samples from the discharge underwater. Kind of a crazy situation, but anyways, and similarly, there could be issues around timing of sampling. The picture on the bottom here, are these showing up very well? They're okay? Okay. The picture on the bottom here is actually combined sewer overflow. If you're going to go and sample a combined sewer overflow, you're going to want to do it on a rainy day where you're getting a discharge from the combined sewer overflow. So timing is an issue. Figuring out accredited lab to work with, you know, as people trying to do private prosecutions, we don't have a lab on site like the government does, so we're working with private labs. We want to make sure it's a credible lab. Researching sampling and testing protocols. Since most of the work we were doing was Fisheries Act, that was pretty easy because the acute lethality tests are well known. And then, of course, the issues around securing transportation of samples to the lab and the legal, I'll talk a little bit about that later, but some of the legal requirements to ensure you have chain of custody and so on. So what to bring was one of the big things that Doug and I would talk about. You know, one of the best things you can do is consult with the lab first to find out what's required to meet the sample requirements, what kind of bottles, what kind of preservatives or filtration might be needed, QA/QC regime. Do you need to do blanks? Do you need to do duplicates? For example, if you're in terms of filtration, if you want to do dissolved metals, you have to filter on site and then acidify the samples. There's all kinds of things to consider depending on what you might be testing for. Measuring devices as well. You know, we always had a GPS, sometimes a Geiger counter too, because we'd sometimes go to low-level nuclear waste sites. The picture right here is of a VOC sampler. Like, you can get these handheld measuring devices as well to bring with you if you'd like, and try and take actual measurements. Documentation was very important as well, especially if you're doing legal, this potential private prosecution or legal samples, in terms of need to take notes and so on, and video and cameras and everything. And then, of course, there's the storage and cooling. You need to keep the samples at a particular temperature. Labs usually recommend between 0 and 10 degrees. I've seen even 8 degrees, 4 degrees, but there is usually a temperature requirement around samples, particularly water samples, that need to be maintained in order for the sample to be, the integrity of the sample to be maintained. And, of course, there's personal protection. Hip waders, goggles, gloves, whatever might be needed to get into the site. And then one thing we always have with us is this funny-looking contraction on the bottom there. I don't know if anyone... Oops. I forgot to advance my slide. Sorry. There we go. That's everything I just read. The thing on the bottom there is a funny-looking contraction is a minnow trap. And because we were trying to do Fisheries Act prosecutions, we always had a minnow trap with us in case so we could show that there was waters frequented by fish. My partner once found one of these in our garage and didn't know what it was. I go, what the hell have you got one of these? And it was going back to the days of when I did these prosecutions with Doug and ensuring we had a minnow trap. These are just some examples of different kinds of sampling containers. That's a SUMA canister, which is used for taking air samples. You can get those from labs as well. And, of course, different kinds of bottles. Some kinds of samples require plastic bottles. Others require glass. That's why you want to be always consulting with your lab. Okay, let me see if I can make sure I remember to advance the slide. There we go. Issues with legal samples. So this is one of the things I was asked to talk about today. There's chain of evidence, which I don't feel as an investigator I'm necessarily dealing with the entire chain of evidence, but I am dealing with the chain of custody piece. Chain of evidence, I understand, takes it all the way to the court, where chain of custody is taking it just to the point of the lab and the analysis. And that's ensuring that your samples are maintained, always in sight, you know, they haven't been tampered with, that there's a consistency there. So Doug always trained me to, you know, always have the samples with me or within my site, or know exactly where they are and that they're locked and secured. Everything had to be properly labeled, name, date, you know, all that kinds of information, who took the sample, time of day, what the sample is, sample numbers, and then, of course, when you're securing them in the coolers, you'd be sealing them. We just used the cheap old method of duct tape. I don't think it ever became an issue that we weren't sealing things properly. Label them as legal samples and so on. And documentation, it was like notes, videos. These all has become easier with smartphones now. We used to have to carry all this stuff around with us. GPS for location of when we were taking the sample. These are all the type of things that we would do. And then the temperature control issue, which I already mentioned. You know, you've got cooler packs or ice packs or whatever to ensure you're maintaining the samples at proper temperature throughout. There we go. So I did look at some cases. This might be a bit embarrassing as a non-lawyer to look at some cases, but I thought it might be interesting to see how some of these issues are dealt with in cases. One recent one, and I see the Environment Canada people left, is this case that came out of just last month out of Newfoundland, Vale case, where it was a prosecution or attempt to prosecute under the Metal Mining Effluent Regular Fisheries Act, and was dismissed on issues related to chain of custody problems. They actually used, it was Vale's just compliance samples to try and lay charges. Do you know this case, Jack? You're nodding? I don't. Okay. It was samples taken pursuant to the MMER, but then they tried to prosecute under the Fisheries Act Section 36.3 for a discharge of deleterious substance without taking their own samples. The officer didn't take independent investigative samples; they just used those ones. Anyways, it was dismissed on chain of custody problems because it was, you know, Vale hadn't obviously done that kind of legal chain of custody with their own samples. So there was no, you know, things that came up in the decision were things like, do you know it was those samples were kept in the dark? Were they kept at, you know, at 4 degrees or whatever the temperature was that they were being told to keep them at? And then when the samples did arrive at the lab, the pH had shifted, which is to me one of the scary things about this case, because pHs will always shift once samples are taken out and moved around. It's just like pH is just one of those things that you take a water sample and then you put it in a bottle and it no longer is able to exchange with the gases. You're going to get some shift in pH, and that should not be a reason necessarily to throw out the sample or the evidence of that sample, but perhaps in this case, if there had been actual proper chain of custody and so on, it might have held. But anyways, I thought that was an interesting one. Another one is a Petrocan case, which is about an oil-water separator and the discharge of oil above a C of A requirement in Ontario. This one was also dismissed because there was really not proper evidence of chain of custody, or there was other problems with the sampling. There was no QA/QC information either provided, and my sense is that was probably there. It just wasn't provided in evidence. I don't think they had anyone from the lab testify. So, and this is just to show that these issues do come up in cases, and obviously charges do get dismissed on these issues. That case actually cites a whole bunch of criminal cases in terms of gaps in continuity, going to weight, and so on, which shows that this is being held kind of at a criminal level in a way. And this last case is a case of like a whole bunch of charges related to waste hauling and waste dumping. And that one actually were the same kind of issues that were raised with Vail in terms of chain of custody and so on were raised in defense. But in that case, the court actually didn't accept those arguments and actually held at least one of the charges anyways related to dumping of hazardous waste. So I thought that was an interesting contrast where it just goes to show you never really know. I guess you're working with JP sometimes too, I imagine. Anyways, moving on now to sampling and testing methods. I was asked to talk about sampling and testing methods, and this is like an open topic that you could go on for months about because there's so many different sampling and testing methods. Advancing the slide, here we go. Many regulations will reference actual sampling and testing methods, such as the Fisheries Act, and I've already mentioned the metal mining effluent regulation, the pulp and paper effluent regulation, which references the acute lethality tests for rainbow trout and for Daphnia magna. Those methodologies are published and available on Environment Canada's website, so you can easily follow them. Other regulations, I'm just pulling examples out here. The CEPA regulations for benzene and sulfur and gasoline, they reference things like the ASTM standards or National Standards of Canada, which are for testing. So I guess the lesson here is just to do your research, know what testing methods are needed. If you can't figure out what testing method is needed, you can talk to the lab. They often know. Sometimes they have packages designed around particular regulations. Or you can start doing research on this various, like this, there's textbooks about testing methods, standard methods of water and wastewater treatment or testing. There's all kinds of standards from the ASTM and SCC. So it's just really a matter of doing the research to figure out what's needed in terms of sampling and testing methods. Just to give you an example, I'm going to show you a chain of custody sheet, a part of a chain of custody sheet from a lab. And this one is basically just set up to, this is for Ontario. You can check off what you need. You're bringing in your samples. Say you're doing a Reg 153, which is your site condition. It's the one about site remediation, about contaminated sites for getting a certificate of site condition. Is that what it's called? Something like that. You check that off. You've got your record of site condition, that's it. You've got your MISA regs here that you can check off. Like, it's just, labs are in the business of they want your business. They want to make it easy for you. So they do often have this kind of information available if you need to know, if you're not quite sure what to test for. Help from community members. This is something else Doug taught me, and I use to this day all the time, is training and talking to community members that are in areas that are having problems, where they've asked you to help them out, where they want you to do an investigation. You teach them how to document what they're observing, how to use calendars and put entries in their calendars when they see things, or when they hear things, or when they smell things. Lots of pictures, videos, that type of thing. Oh, advancing my slide, sorry. For example, this picture was just taken with somebody's cell phone of an obvious upset at a major facility, a refinery in Sarnia. Lots of black smoke. That's definitely an opacity violation. Then using things like stink scales. We have clients at EcoJustice that use this. When they smell something, they'll describe it on a stink scale. They say, well, that one was a 4, well, that one was a 9, and they'll write it down. And it really helps to document the evidence, or put the evidence together in terms of what they're observing. This picture on the bottom here actually is a tool available to citizens. It comes from a group in San Francisco called Global Community Monitor, and it's called a bucket sampler. There's communities all over the world using these now to take their own air samples. I don't think it's ever been tested in court in Canada, whether it would stand up.
Those pictures look familiar.
No, this is actually not, it's not what you think. I know what you're saying, but I wanted to put that one up, but I didn't want to get you going, so yeah. Anyways, yes, we've used these in Sarnia, to say the least. But anyways, but this is just off their website. But it's basically a Tedlar bag, and it's a little pump attached to it, and you can suck in an air sample, and then there's a lab in California which will analyze it for you. And my understanding is it's a recognized method by the US EPA. They've certified it, it's a recognized sampling method. So being used in Canada, not very much, but there's lots of opportunity for more. It is a little expensive for communities. I think it comes to around $400. Maybe with Canadian dollars these days, it's a lot more than that. But to get it analyzed, but it's a helpful tool as well for taking samples for communities. And then StackWatch. I'm going to talk about StackWatch for a minute because this is a really cool program Environment Hamilton started. Environment Hamilton is a NGO. Started by Linda Lukasik, and she used the money from the Lukasik versus Hamilton prosecution to start Environment Hamilton, because of course there's a bounty splitting provision in the Fisheries Act, so she got part of the fine, and that's how she started up Environment Hamilton. So Environment Hamilton has this program called StackWatch. Anyone that knows Hamilton knows that it's a very industrial town, lots of big steel mills and lots of stacks. People are really concerned about air pollution in Hamilton, and studies do show that it's quite high in some things like PAHs, polycyclic aromatic hydrocarbons like benzoate pyrene and benzene and stuff like that are quite high, particulate matter obviously, and so on in Hamilton from industrial emissions. So they have a website to train citizens on how to observe the stacks. They have a key, a photo key, so people know what stack they're looking at. They describe what opacity is, and we still have rules in Ontario on opacity. And what opacity is, that people can note when there is opacity emissions happening. And after undertaking this, and of course then they tell people how to contact the Ontario government, the Spills Action Centre, and report any opacity violations they might see or alleged violations. And this efforts did result in MOE getting going and actually prosecuting ArcelorMittal Dofasco on 13 charges. They've pled guilty to 6 for opacity violations and a $390,000 fine in 2013. So they're citizens kind of taking things into their own hands and then pushing the government to take enforcement action. The next one was one that I was involved in, case study 2, of a, there we go. This one is relates to some spills from a Shell refinery in Sarnia that happened back in 2013. And we filed something called an Environmental Bill of Rights request for investigation under the Ontario Environmental Bill of Rights of these spills. These spills were spills to air of like noxious sulfur compounds. They made people in the local community, which was the Aamjiwnaang First Nation, feel very nauseous and sick, rashes, or at least they thought it was because of the spill, burning eyes, that type of thing. So I, with the help of a local resident, basically collected a whole bunch of evidence, and we helped her file that with the Ontario government as part of an EBR request for investigation. This is just a little cutout of some of the evidence that she took notes of what everybody was telling her, were their experiences. We had names. We gave that all to the MOE, hoping that they would use that to then run with it and investigate. In the end, MOE refused our request for an investigation. They just said no, and they don't really have to do anything more than that if they don't want to, which was disappointing. The Environmental Commissioner of Ontario was fairly critical of MOE for doing this in his annual report. I urged ministries to consider the benefits of accepting an EBR application or investigation even where the ministry investigation is underway. The EBR process would have added greater transparency and accountability to the investigation, was one of his quotes. And then he talked about the systemic issues in particular in this community. Ongoing health and environmental difficulties in this community continues to make the ministry's failure to address the systemic issues highlighted in the application especially distressing. So what happened is we filed it, the MOE said no, then the ECOS report came out, critical of the MOE. for rejecting, I should say MOECC, sorry, critical of rejecting our application. But then we did get some good news come almost the end of the expiration period, so just January 2015, of days before the limitation period ran out. And we did lay charges against Shell for one of the 2 dates in which we had filed the application for review. And on November 24th, so just a little while ago, Shell pled guilty, $500,000 fine plus $125 victim surcharge, and was in a unique sentencing, was ordered to also pay the Armstrong First Nation $200,000. So that was kind of a cool result, even though we were disappointed by the fact that they had rejected our application. We like to think we still had a role in making that happen. I don't know. Maybe we're overthinking it, but who knows. Anyways, that was another case study. So this is my last slide, really. The only other thing I want to point out is there's lots of sources of information out there. The field stuff is a minor part of my work compared to all the other stuff I do in terms of gathering information and data and evidence. I use FOIs and ATIPs. There we go. Public databases, registries, portals. Portals is a strange name, but that's actually what Environment Canada calls their website where they carry all the tar sands data on their analysis. Reading rooms, like PMRA, Pest Management Regulatory Agency, has a reading room where you can go and look at documents. You have to swear an affidavit to do it, and you can only use the information you're looking at for the purpose of commenting on a proposed decision, but still it's a place where you can get information. Open government websites, I'm finding governments are putting more and more, not so much our last government, but I'm starting to see an increase in information being put in open government websites, including things like GIS data. If you're into that, you can do great mapping and overlays and see how different things overlay with each other. SADAR, I use that just because it's interesting to see. SADAR, for those who don't know, is where you publicly traded companies will have to report their annual reports to the regulator of, for publicly traded companies. So you'll have like annual reports to state shareholders, and it's always interesting to see what companies are reporting to their shareholders, how they present their work and their issues. Tons of scientific literature, gray literature, and reports as well. Always talking to experts, another thing you can do. Informants, I don't think there's as many, like people think there's lots of informants out there. Really, I don't know where they all are. I've had a few in my time, but there's not really that many informants, but it's nice when you do have one. Personal connections, of course, and then sometimes you get information just by asking.
What's gray literature?
I like government reports and like not academically published reports, but things you might find on government websites or agency websites and that type of thing. So I hope that was helpful. Sorry for forgetting to advance my slides a couple of times there. Thanks. Thank you.
Thank you so much. That was very interesting. Okay, I have one question. In certain U.S. jurisdictions, private labs are certified for specific kinds of analytical work and not for other kinds. In environmental cases, only certified labs can analyze, for example, VOX or PNAH, etc. Does a similar lab certification system exist in Canada?
I know that SCC, the Standard Council of Canada, offers a lab certification. Sorry, I should be at the mic. I also know ISO, for example. You can get ISO, I believe, certification. Not quite sure if it's the same as in the U.S., but there aren't that many labs in Canada. They've kind of all conglomerated. Like the big one in Toronto is Maxim, and it's just.
No, it used to be Callan. CAEL something. And I think whoever asked the question is the limit on that, but they'll certify it by.
The answer is
Yes.
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 Okay. But yeah, and they certify by contaminant, so not just the lab, and they do need to have quality.
Oh, by contaminant.
They do their own quality control, but then you have to check for the analyte too.
Okay.
Thank you. We have another question here. Wasn't there a question back here? No, I thought there was a question back there. Yes, great.
Hi. So I'm not a scientist, so I just have a question, though, about, in your experience, how do regular citizens like the ones you were speaking of that were located at this reserve, how do they engage the services that your organization offers, I guess? Do they have to come together and pool their funds? Or
no, I should have explained that EcoJustice, as a charity, we provide our services for free. So we fundraise basically in order to do the work we do. So we do charge for the disbursements, obviously. Right. I usually have a slide in the beginning that explains EcoJustice, and I didn't put it in for some reason. But anyways, if we do get into a situation of litigation, there are disbursements that have to be covered. But otherwise, the lawyers' and scientists' time are just funded through our fundraising. But then we don't just take on anything. It's not like a service situation where somebody can just come to our door. Because as a charity, we have a mission to strengthen environmental law in Canada. So we only take strategic cases and cases that we think help meet our goals. So we get something called NCIs, which are new case inquiries. Most of them we reject because we're just not, and they don't fit into our goals as a charity.
It's interesting. I grew up in a town called Trail, British Columbia, and we have Teck Cominco lead refinery. And growing up, the whole lead and the air quality issues were a huge factor. In fact, it became a grassroots movement, so to speak, where citizens formed up with public health, and they created what was called the Lead Task Force. And they would send people to your door, and they would come in and educate families on, like, we always kept our shoes outside. And even when I moved to Ottawa, it was still stuck in my head to do that. And people are like, why y'all leaving your shoes outside? Yeah, exactly. It's very fascinating work you do. Good job.
Yeah, thanks.
We have 5 more minutes if there's any other questions. Yes.
Sorry to keep bringing up that you didn't put that slide at the beginning that you would normally have about EcoJustice as a backgrounder. Yes. But on the same line of questioning, if everything is done by charity, I just have a question about the lawyers. Do you have staff lawyers, or is there sort of a roster of lawyers who do pro bono work, that sort of thing?
No, we have what we call staff lawyers, but they all work. It depends on the office. We have an office. Okay, I'm going to do the EcoJustice thing now because I didn't do it in the beginning because I assumed everybody know who we are, but we have an office in Vancouver, Calgary, Toronto, and we actually have a clinic here at the University of Ottawa as well with 2 lawyers. We do law reform as well as litigation. We do mostly admin law, I must say. Prosecutions, not so much. We do a lot of judicial reviews, a lot of interventions. But we have staff lawyers, and depending on the office, I think because the legal profession is regulated provincially, if I'm right. I might get this totally wrong, and I might get called out by my colleagues when I get back to Toronto. But anyways, I think it depends on the office, but some of them are independent lawyers working under EcoJustice, and others are staff lawyers working under EcoJustice, but depending on which province it is. But yes, they are on salary. They don't make what Jack makes, but they are quite happy with what they do, and they just. Anything else?
In Ontario, you're all independent.
Yeah, that's right. Yeah, and versus I've heard in Alberta we're not. So they work as a law firm. So in Ontario we're not really a law firm. We're an organization that has lawyers. I don't actually understand the difference. So someone else should be here answering this question.
Anybody else? Okay, well, thank you so much. That was a very interesting panel. And so we'll just...
Thank you.
So just another quick health break, and then we'll take up the next session.